Best with Paula Haddock and Joanna Canals.
Happy Friday, everybody. Welcome to Colorado's Best. I'm Joanna Canals. Paula Haddock will join me in just a few minutes. She's just sitting on the side because we've given the main chair to Phil Harding. Today we're talking about our court systems and a huge change that happened on January 1st of 2019. That was a quick camera change. You ready for it?
Yeah. I think I am ready to go.
Our legal expert Phil Harding is in today. What are we talking about today?
Well, I thought it'd be a good and an important time to touch on basics. I get a lot of calls of people who want to know, hey, I want to file a small claims action. Happy to tell you about that. But we're going to go over the different levels of our court, talk about the state legal system and how you can move between each level. Everyone throws out, let's start off with some basics. Everyone throws out like plaintiff and defendant, so let's talk about that. First of all, plaintiff, you need to remember, is the person who brings the action. It's also known as a petitioner sometimes, like in a divorce proceeding, and if you are the one who files an appeal, you are the appellant. Now, the defendant is the person who is getting sued, right? Also known sometimes as the respondent, and if you are responding to an appeal, then you would be the appellee. So those are just some basic things so that we can understand the most basics of this. Now, I want to look at the different levels of the court systems, and let's start at the lowest, which is small claims court. And look, small claims court is, that's county court. Do we have small claims court, or should we start with county court? All right, we're going to start with county court. Let me tell you about county court. That's one level up from small claims court, and this is where attorneys are allowed. This is what just changed. Up until January 1st, 2019, it was a $15,000 jurisdictional limit. So now it's got pumped up by $10,000. So now it's $25,000. Attorneys are allowed in county court. You can have a trial in front of a judge or a jury, and the defendant must file an answer, and then you set a court date. Generally, these court dates are pretty fast. They're within months, and then the judges and the magistrates can rule immediately, or they might send out an order afterwards. So county court is kind of a jurisdiction of up to $25,000, so from $1 up to $25,000. Now, I want to talk about small claims court, and hopefully we have a graphic ready for this.
We don't have that one, so let's move on to district court.
All right. I do want to talk real quick about small claims court, even though we don't have the graphic on that. Jurisdictional limit is $7,500, and here's the great thing about small claims court. Attorneys are not allowed in that. So you file this lawsuit, and then you go in front of a magistrate. They have nights, they have weekends available, so you will file that in the jurisdiction where the defendant, remember the person that you're suing, resides. All right, now let's go to district court, because district court is what's known as unlimited jurisdiction. So you can file it for a penny, you can file it for like a gazillion dollars. So that's really important, but usually attorneys are involved in district court, and trials are set for like a year or more out. There is what's known as pretrial discovery, whereas in small claims court and county court, they're not allowed, but pretrial discovery is like calling someone in for a deposition or sending out written discovery, which is called interrogatories and so forth, and motions are filed, like to exclude evidence in front of a jury. So those are the three different levels, and now let's talk about how one moves between one and the other. So
are we talking about appeals court now?
We are. We're going to go on appeals, and it's not really appeals courts, but each one of those is really an appellate court. So let's say you were in small claims court, and this is at the bottom. You don't like that answer, or you don't like the ruling, you can go up to county court. County court, your decision would be appealed to district court. Now, district court, if you get a ruling, that would go up to the Colorado Court of Appeals. And then finally, if you don't like the decision in the Colorado Court of Appeals, you would go up to the Supreme Court. Something really important to know here, you only get one appeal by right. So if you're in small claims court and you file it up to the county court and county court agrees with small claims court, you don't automatically get to go up to district court. You have to ask for permission. So you get one appeal by right. All the rest of them, you have to ask permission to get.
So you're on every Friday with us, and you bring us information that we don't get from anywhere else because, you know, you're the insider when it comes to legal things. Why do you think people need to know these things?
I get calls lots throughout the week of people that want to know about small claims court, and they say, hey, someone filed a lawsuit at small claims court, what do I need to do? Most important thing, if someone has sued you, you need to respond right away. Get an attorney, and if you're in small claims and you do get an attorney, it automatically goes up to county court. But if you don't respond, you're going to get a default against you, which means the other side comes in and whatever they want, the judge is going to give them. So watch out. If someone files a lawsuit, don't just throw it away. It's super important.
All right. Thanks, Phil. Thanks for always bringing us great information. And if you have a question for our legal expert, go to kwgn.com and click on Colorado's Best. You're going to see Phil Harding's photo on the right. Just click there and send in your questions. He will answer each question personally and confidentially. And to reach Harding and Associates directly, call 303-762-9500. You can also get a free consultation anytime, and you can find him online at hlaw.org. Well,